matter of Deutsche Bank AG, Sebastian Holding and others.
Yes, Mr Matthews.
May it please you, my lords, my lady. I appear on behalf of the appellant, Mr Vik, together with Mr Rupert Hamilton and Mr James Gardner, and Sonia Delaney, King's Counsel, appears on behalf of the respondent, Deutsche Bank or DBAG, together with Mr James MacDonald, King's Counsel, and Mr Matthew Hoddle.
Thank you.
My lords, lady, I proposed to start just to see where the court had got to on the permission to appeal point. Your lordships and my lady will have seen that neither side is contending that permission to appeal is required, and permission to appeal has not been sought. Both sides have put in paper submissions in relation to those, and I hope the court has seen those.
Yes, we have. Thank you.
I'm grateful. It is therefore perhaps in some ways unhelpful if from the court's indication common ground between the parties that no permission to appeal is required. I wasn't proposing, unless the court would find it helpful, to take it in any further detail orally. One thing I was going to just clarify, it's been flagged up by Deutsche Bank as to whether they are clear, and perhaps therefore whether the court is clear as to what we are appealing. So I thought I would deal with that. We've dealt with it in our submissions in the bundle relating to that at paragraph 2 of our submissions and footnote 1. There's no, we submit, real confusion on the part of Deutsche Bank as to what we are appealing, and I hope no confusion on the part of the court. Indeed, Deutsche Bank have covered what we are appealing in their skeleton, which rather shows that they don't really have any confusion. We are, of course, appealing the committal order and the underlying findings of contempt which underpin that committal order, and we are appealing against sentence, whether or not we are wholly or partly successful in appealing the contempts which underpin the committal order.
Yes, well, we wanted the point to be ventilated because it has come up in some other cases.
Yes.
And you've given us some submissions on both sides for which we're grateful. I don't think we need to hear you orally on the question whether you need permission. Ms. Delaney's submissions, to paraphrase them unfairly perhaps, say you don't need permission, but, and there's a bit of a but on the end of it. Well, if that may be something that needs to be addressed, but not the principle of permission. As we see it at the moment, you don't need permission to appeal from the committal, and you are entitled, as a ground of your appeal from the committal order, to say that the findings of contempt should not have been made. Whether you would need permission if you were seeking to appeal from the contempt order in the absence of committal would be another matter. Yes,
well, if I can take your lordship just briefly to the orders in the core bundle, tab 7 is the what one might refer to as the contempt order.
Yes.
And that one contains the recitals, particularly at pages 170 to 172, as to the contempts which were found by her ladyship below. But if one looks at the terms of the actual order at page 172, one sees, first of all, that matters of mitigation, sentencing, costs, arrangements for further questionings, and so on should be adjourned to another hearing. And of course, that's been and gone, and we don't appeal that in and of itself. Paragraph 2 was that skeleton arguments should be filed and exchanged, and that's been and gone, and we don't appeal that in and of itself. Paragraph 3, which may be significant in the light of earlier authority in this area, particularly from my Lord Justice Nugee, to the extent Mr Vik wishes to appeal the findings set out in the table above and or any order made at or following the hearing, that's the sentencing hearing, referred to in paragraph 1 above, the time for filing Mr Vik's appellant's notice will not begin to run until the date of any order made at or following the hearing, referred to in paragraph 1 above. So that is getting the adjournment and the postponement of the time for appeal of the findings pending the committal hearing, in the sense of the sentencing hearing. And then paragraph 4, Mr Vik is to file any evidence he wishes to rely upon in connection with mitigation or sentencing. And again, that has been and gone, and in that of itself, we obviously don't appeal that. So if one looks at the terms of the order from the first part, although we formally have served a notice which covers both orders, it is, I accept, difficult to see what particular aspect of that one might want to challenge, pending and without the court having proceeded to the order at tab 8, which is, of course, the real gravamen of the hearing before this court. Mm-hmm. And the order at tab 8 is the order of committal. And in that, of course, there is the recital at the top of page 174 of the contempts found with the cross-reference to Schedule A of the order where they are set out, beginning at page 175. And if one looks at that order on page 174, it is clearly that order which is essentially what we are appealing before the court today. Paragraph 1, obviously the sentence of committal, and we challenge the contempt findings which underpin that order as part of the challenge to that order. And paragraph 2, the suspension of that, obviously there is, in a sense, an ancillary appeal to that, because if and insofar as there is no sentence of committal, then that would go as well. And then paragraph 3, costs, that would also, as an ancillary matter, fall to be dealt with on appeal depending upon the outcome on the substantive appeal. And number 4, the liberty to apply to purge would also go if we are successful on appeal on paragraph 1. So there are ancillary elements. Clearly the paragraphs 5 and 6, again, are matters which are been and gone and therefore do not warrant and are not part of any appeal. Yes. So I hope, if it wasn't before, it's clear now what we are appealing, and that what we are appealing falls comfortably within the scope of what my client is permitted to appeal without permission, and therefore we have not. Obviously, if the court should determine of its own motion and contrary to the submissions of the parties that appeal, permission to appeal is required, then we would seek permission to put in an amendment to our application to add permission to appeal to deal with that. But we don't anticipate that that would be a constructive use of time at this stage of the proceedings, and I therefore leave that on one side. Yes, for now. The second subject to anything the court has in relation to that, I was then going to move on just to mention, for reasons that I will explain, the applications of which there are 2 to admit additional evidence. They are to be dealt with on paper, and I don't intend to develop them, therefore, as it were, abusively orally. However, what I thought I would helpfully do to the court is, when we get to the relevant point, just mention it so that the court is aware of how it fits into the grounds of appeal and the points raised by my client.
Well, I think I ordered, at least in relation to the earlier one, that it should be dealt with at the hearing,
yes,
as distinct from on paper, because at that stage it seemed to me that it would be necessary to do pretty much as all the pre-reading in the case, or at least a lot of it, in order to understand what the point was about. But now that we've got the points and got your submissions from both of you, it seems to us that the best way is to look at that evidence de bene esse. We'll give a ruling on it so far as we need to in the judgment, and in the course of each of your submissions you can make such points as you want to about what the evidence shows and whether it should be admitted.
I'm very grateful, my lord. That's very helpful. And on that basis, I then turn to the substantive appeals, and of course I begin with the introductory remarks that this is a decision of the court below which is based on inference, and therefore, as is made clear by the judgment in Abiazov, which we deal with in our skeleton at paragraph 31, and you have in your authorities bundle at tab 23. Paragraph 8 of that judgment, as the court will be very familiar, knows that is obviously a matter that requires particular care. The background being, of course, that a committal committal hearing or contempt hearing requires the applicant to establish to the criminal standard the matters complained of, and that is particularly an acute issue in circumstances where the entirety of the case is based upon inference rather than otherwise. Obviously, we recognize the metaphor that has been used in relation to judgments based on inferences of the concept of the net closing and the preponderance of proven facts making it improbable that the accused is not guilty. That, of course, works, but this does not mean, of course, that you don't have to prove each of the underlying facts in order for your net to close. And if the position in relation to any of the parts of your net is undermined, then the net does not close, and the findings of inference cannot stand. And
I mean, it is a case about inference, but it's no different from any case where the issue is what somebody knew or intended, because unless they come along and, as it were, confess this is what I knew or intended, then it is going to depend on inference from the established facts, isn't it?
Up to a point, my lord, but there are various ways in which the fact of somebody's knowledge or intention can be proven, and there are other cases, such as this one, where there is no direct evidence of the knowledge or intention of the parties, and it is drawn from inferences. One would take, as an example, and I'm going to come back to this in a little bit of detail, the circumstances surrounding the conclusion of the sale agreement in 2012. And there is undoubtedly a document which purports to be a 2012 sale agreement. It has been held without, with respect, explaining quite what is meant in this context, that it was not a bona fide agreement. So I'll come back to say it's not clear whether it's being suggested that it wasn't entered into at the time, namely at some point prior to 2014, presumably, though, as I say, it's not explored, or whether rather it was entered into in 2012 or prior to 2014, but doesn't, for some reason, reflect a real agreement between the parties. And so that is, prima facie, you've got a document which has been entered into at that time, and if it is to be demonstrated that it was not entered into at that time, that there are various direct bits of evidence that one could produce. One could produce somebody who said, I didn't enter into it at the time, or I was asked to advise on its drafting or something at some point, and therefore you could prove directly that that agreement had not been entered into in 2012. That is not this case. This case involves drawing inferences from a range of other bits of information, and as I'll come on to at the moment, crucially, and very importantly for the judge's reasoning, starting with the question of credibility of Mr Vik, and in relation to a finding in the prior case between Deutsche Bank and SHI as to Mr Vik as a witness having been involved in the fabrication of an oral agreement. And it's from all of those things that fundamentally the learned judge came to the conclusion that she did, that the 2012 sale agreement was not bona fides. So there it is a case essentially based on inference. There's no direct evidence which assists. It's drawn from matters relating to the credibility. It's drawn from supposed inconsistencies within the document itself, such as the fact that it references Norwegian law, but there was an earlier comment by Mr Justice Cook that Norwegian law didn't know the concept of the trust, and I'll come back to that in the context of one of the items of additional evidence on Norwegian law, of which there was no evidence before the judge. And so things like that have been agglomerated in order to lead to a conclusion that this document, as a matter of inference, was not entered into at the time. Now, that we say is an area where the court has to be particularly careful, and the starting point which the judge adopted in relation to all of this, and therefore the point at which I will also start, is the questions of credibility. Now, the judge's approach to credibility was fundamental to the judgment. She started it relatively early in the judgment at page 192, paragraph 49, and it goes through to page 205, and then the judge comes back to her conclusions on general credibility in relation to the specific allegations of contempt, and identifies, when she comes on to the specific allegations, essentially, well, first of all, I don't believe Mr Vik when he gives evidence because of the findings that I have made in my general section on credibility. And we say that the court's approach to credibility was fundamentally in error. We deal with it in detail in our skeleton argument at paragraphs 29 to 73. And the key to our criticism of the approach of the judge is as to her approach to Mr Vik's credibility generally, and her subsequent reliance upon that in relation to the specific allegations of contempt. In effect, she not only decided that Mr Vik was not a credible witness based upon the general findings that she made, but having done so, she thereafter decided everything against him, in essence giving the benefit of the doubt to the prosecution and not to the accused, because what effectively she said was, I don't really accept his evidence unless it's substantiated by a reliable document, and because of my conclusions on Mr Vik's credibility in relation to documentary evidence, I take a very cautious approach in relation to documents too, because I have formed the view in relation to Mr Vik's general credibility that he has been dishonest in relation to specific documents and their production, and therefore I view with great scepticism any document that's put before me as well. So Mr Vik is in significant measure put in a very difficult evidential position by reason of those general credibility findings that her ladyship found at the outset. And the starting point of our case is that she made those findings on a basis or an approach to credibility which the learned judge was not entitled to do. But the extent to which we say that her subsequent decisions on the specifics of the allegations of contempt are infected by the general credibility findings are, by way of example, and I'll come back to them, but in our skeleton argument, paragraph 30, footnote 2, we cross-refer to a particular range of the passages later in the learned judge's judgment where her findings on general credibility come back stage centre each time she assesses the evidence in relation to the specific allegations of contempt. Therefore, if there was a credible explanation urged upon her by Mr Vik and an alternative urged upon her by Deutsche Bank, she accepted the latter because she had formed the adverse view of Mr Vik's credibility and therefore, in effect, declined to accept the veracity of anything that he said in evidence unless it was proved by a document which she was satisfied was proved to the requisite standard.
What is the consequence if you're right about your submission that her approach to credibility was fundamentally flawed? Does that mean we allow the appeal and declare that Mr Vik is not guilty of contempt, or will it have to go back to a retrial since we can't really form a view about his credibility ourselves?
Well, I would acknowledge that both options are available to the court. We would urge the court to set it aside on the basis that it was clear from the judge's approach that she adopted an approach to credibility which was, for the reasons we'll come on to identify, flawed. Therefore, since she relies, I don't mean this disrespectfully, indiscriminately, when she comes on to the findings on specific allegations of contempt, on those general findings on credibility, clearly the judgment cannot stand. And therefore, in those circumstances, the court has the option whether to set it aside and send it back for a further trial, or to set it aside and leave it at that.
And you've got, as I understand it, 3 general points where you say that the judge's approach to credibility was flawed, and no doubt you'll come to them.
Yes.
And I can see that if you're right on them, then your submission that later findings are infected has force. On the other hand, if you're wrong on them, she's entitled, isn't she, to take findings about Mr Vik's credibility into account when dealing with the specific allegations. That looks to me like the kind of thing that judges would do all the time once they've formed a view of a witness.
Yes, I have to acknowledge that the court doesn't start with a complete clean sheet as if nothing had gone before. And the effect, though, we say, was because every occasion thereafter in which Mr Vik produced a credible explanation, given that the judge should have been reviewing the allegations by reference to the criminal standard of beyond reasonable doubt, if there was a credible explanation, she should have accepted it, rather than assumed that it was wrong, which is in effect what she did by reason of her verdict on Mr Vik's general credibility, and therefore rejecting his credible explanation.
I mean, one way of looking at it, I suppose, is to see what the position would have been if Mr Vik had not given evidence. The question would then be whether the bank's submissions and Mr Hart's evidence mounted a sufficient case to prove the contempts to the criminal standard, and the judge would have to make up her mind about that. But then if Mr Vik gives evidence which, for good reasons, is not credible, then if the bank gets over the first hurdle on their evidence, that is simply not displaced. Is that a fair way of looking at it, if you're wrong about your general challenges to her findings on credibility?
Well, the difficulty is that you cannot ignore the evidence that Mr Vik did give. And if the judge rejected the credibility of his account of events by reason of her general conclusion on credibility, then you have the difficulty that, yes, you have Part 1 and the submissions made on that, but you do also have evidence which should have been accepted as credible insofar as necessary explaining matters and proving in the sense that it is evidence unless disbelieved as to, for example, the validity of the 2012 sale agreement.
Well, isn't that a circular argument, Mr Matthews? You say that you park to one side the general findings of credibility, and you say, well, there's evidence which in isolation should be accepted as credible, but that begs the question of whether or not that evidence is being given by a credible witness. And if there's a finding of adverse credibility which is sustainable, then it seems to me that the judge is entitled to say that I don't believe him. Whereas if that general finding of credibility is unsustainable, then you've got a point.
Certainly we accept your latter point, my lady.
Of course you do.
The first point we're not quite so at one with. The position, as I accepted from my Lord Justice Mayles, is that we acknowledge that the judge is entitled to, and invariably does, form a view as to the credibility of a witness. The difficulty, though, is in circumstances such as this case, where credibility then lies at the heart of the reasoning of the judge for rejecting the explanation given by the witness and the evidence given by the witness as to the veracity of documents, as to having entered into agreements and so on, which are evidenced in writing. It's not possible, if one has rejected the credibility approach, to then say, well, I can nevertheless ignore that evidence somehow and form a view simply on the basis of Part 1 and submissions. I may have misunderstood the point, but my difficulty with that is that if we have successfully demonstrated that the approach on credibility is flawed, then you have evidence from the witness. You don't just have Part 1 and the submissions of Deutsche Bank.
Well, I thought we were at one on that. I mean, I thought the point that we were at least in some agreement on is that if you succeed in showing that the judge's general findings on credibility were ones that were not open to her, they're flawed in any particular, in a legal manner, then that will potentially taint all the subsequent findings. Got that, understand that. The point I'm struggling with is how you can say that there is, on a specific finding, let us assume that you haven't done that, let us assume that she has made a general adverse finding on credibility that is not tainted. What you submitted, I think, about 5 minutes ago was that nevertheless she should have accepted as credible the evidence on the specific finding. And I was simply pointing out that that's rather a self-serving argument. It becomes circular because it presupposes that evidence is being given by a credible witness. And if she's found that the witness is not credible, why is she bound to believe him on this?
I think there are two elements of response to that. The first is that in order to displace the, well, it should be the other way around, of course, in order for the prosecution, as it were, to establish the guilt as to the items of contempt, it has to be proved beyond reasonable doubt that the contempt alleged took place. And in order to establish that, if there is a reasonable explanation which would undermine that conclusion, then by definition the court cannot be satisfied beyond a reasonable doubt that the contempt is made out.
If the reasonable explanation is being put forward by a witness of truth. You don't just have a reasonable explanation in the ether.
Well,
You can test it. I fully take the point that if there is a reasonable explanation, the judge can't simply say, well, I think this witness is lying generally, and therefore I can't believe him on this either.
yes.
If that's all you're saying, then I understand the point. But you can't say that she's not entitled to say, well, as part of the evaluation of this explanation that's given, I simply don't believe it, because if it came from a witness of truth, I might have done. But actually, I think he's lying about this as well.
With respect, I would suggest that it can't be disbelieved simply on the basis that it comes from the mouth of a person who has failed on general credibility. One cannot approach it on the basis of how do you know this witness is lying, because his lips are moving. If the evidence is there to counter the argument or the evidence that the witness has given, then that is undoubtedly a reason why you might say, although I've got Mr. Vik who tells me this, I've got this document which tells me that, and I prefer the effect of this document to the evidence of Mr. Vik, because I'm evaluating the two. But if you have the evidence of Mr. Vik that this is what happened, and you don't have something which undermines it, you can't simply say, but I nevertheless disbelieve Mr. Vik because he spoke. You have to have some rational basis. Otherwise, effectively, somebody becomes an outlaw. I mean, they can't give evidence. There's no point in them giving evidence, because they're simply, anything they say is to be disbelieved.
Is your point that just because she made, on this assumption, perfectly sustainable findings as to the unreliability of Mr. Vik as a witness, that doesn't mean that she throws out all his evidence as if he hadn't been given at all? She still has, on each issue, to weigh up what he says, whether that explanation is one which gives rise to a reasonable doubt or not. But in weighing it up, she's not only entitled to look at the other evidence, the documents and the inherent probabilities and so on and so forth, but she's also entitled to take into account the fact that she has already found that he's not a witness who is reliable and credible, and can put that into the assessment of whether she thinks that what he says on this particular point does give rise to a doubt or not, a reasonable doubt. That
was what I was struggling to express, my lord.
Well,
I'm grateful.
I don't claim to have put it in any better way than you have, but I was just that is the mere fact that you've concluded a witness is unreliable, something that all trial judges from time to time do find, doesn't mean that you then reject everything that the witness has said as if he hadn't been called at all.
Absolutely.
But what he does say has to be measured against the fact that in general he's not necessarily to be regarded as a witness of truth.
Yes.
Well, for my part, I don't have any difficulty with that as a general proposition.
I'm great. Yes. If approach, as I say, which the learned judge took, was first to take into account a range of factors in reaching her conclusion on general credibility, and that is our starting point. In doing so, she went fundamentally, with respect, wrong, and then to recognising that that approach infects her approach to the individual issues. She didn't. Well, she started in relation to the other issues with the proposition, because of my findings on general credibility, I don't believe this witness, and that's number one of the factors against Mr. Vik. And obviously, if she's wrong in her approach on general credibility, that goes in relation to the specific allegations.
Well, I wonder, I mean, this is all on the assumption, of course, that contrary to your principal case, she's entitled to reach the conclusions about his credibility generally. But on that assumption, she directs herself at paragraph 51 that if the court finds that Mr Vik has told lies on other occasions, it doesn't necessarily mean that he's lied about everything. And she says at 103 and 104 that Mr Vik lied to this court when faced with clear documentary evidence. For all these reasons, I approach Mr Vik's evidence on individual issues with considerable caution. She doesn't say, I disbelieve everything he says just because he's a liar on other matters. She says she'll approach it with caution. What's wrong with that?
I was moving on, sorry, to the point at which I was going to address the first point, and therefore my analysis on what I said just before your Lordship's intervention was on the premise that there was a wrong approach.
All right. Well, you move on. We've probably interrupted you enough for a while.
I mean, the short answer to what your Lordship says is, if I'm wrong about the general approach to credibility, we still say that her approach to general credibility, when bringing that into account on individual findings of contempt, goes beyond how she directed herself at 51 and 104. But I'll come back to deal with that in relation to the specific transactions. I was perhaps too slowly segueing into my first point in relation to the general approach. The three key flaws to the judge's approach on credibility which we contend for are, first of all, her use of prior adverse findings to the civil standard. Essentially, I'll come back to it, but it is essentially findings of Mr Justice Cook, and the others, as I will explain, being essentially all parasitic, if I can use that word respectfully, in relation to other judges' decisions on that finding of Mr Justice Cook, those findings of Mr Justice Cook. The second was the relevance of findings in respect of abandoned allegations, or allegations that were not formally being pursued. And this, in particular, engages the position in relation to what are referred to as the partnership interests, namely, specifically, Carlisle and Wrighton, and as a subsidiary issue to that, the question of the ownership of Sarek, to whom partnership interests in Wrighton were transferred. And the third item is that the learned judge, in effect, adopted an unrealistically high standard in assessing the evidence given by Mr Vik, imposing an impossible burden upon a witness in proceedings such as these. If I can turn first to the prior adverse findings to the civil standard in a case in which Mr Vik was not a party, and therefore not, of course, giving rise to any question of issue estoppel, we deal with this in our skeleton argument beginning at paragraph 33. Deutsche Bank relied and continues to rely in this court heavily on prejudice constituted by prior adverse findings in relation to this dispute between Deutsche Bank and SHI. We had cited some examples of that in our skeleton argument at paragraph 34 and footnote 3. Since then, Deutsche Bank has doubled down in its skeleton for the Court of Appeal. In paragraph 1 of its skeleton argument, Deutsche Bank describes Mr Vik as a thoroughly dishonest individual. In fact, apart from to a limited, though I accept significant extent, and in relation to this litigation only, there is no evidence to support that allegation. Mr Vik is not some sort of serial con man, but a gentleman in his late 60s with a long, successful, and aside from this dispute with Deutsche Bank, an unblemished career in business and finance, and there neither was nor is evidence to the contrary. Even in relation to this litigation with Deutsche Bank, whom Mr Justice Cook found to have been in their turn dishonest and stupid in their dealings with SHI, the wide range of adverse findings to Mr Vik referred to and relied upon by Deutsche Bank are, with respect, overstated by Deutsche Bank. So if one takes, for example, paragraph 3 of Deutsche Bank's skeleton argument, they rely somehow independently on a finding of Mr Justice Tier. Mr Justice Tier's finding in that case was entirely parasitic on the findings of Mr Justice Cook. He did not see or hear any additional evidence to support that finding that is referred to. Mr Justice Cook's findings in relation to Mr Vik as a witness are in truth the basis of all the further findings relied upon in the various other courts, or referred to in the various other courts, which are, as I mentioned earlier in that respect, parasitic. They do not represent in any sense independent analyses of Mr Vik's evidence. And prior to the decision of Mrs Justice Moulder, there had been no finding against Mr Vik of dishonesty to the required criminal standard of proof. And therefore it is in effect bootstraps when Deutsche Bank, as they do, seek to rely upon and assert Mrs Justice Moulder's findings as underpinning that general attack on Mr Vik, to be set against the findings of Mr Justice Cook. There is also the finding of the court in the Connecticut proceedings, which were directly between Mr Vik and Deutsche Bank, and they did specifically engage the issue of the honesty or otherwise of the transactions by which Mr Vik transferred assets in 2008 from SHI. The Deutsche Bank, in their skeleton argument at paragraph 27, say that it is of key relevance that Mr Justice Cook held in the litigation between Deutsche Bank and SHI that Mr Vik had sought to judgment-proof SHI. But in the Connecticut proceedings, which I'm coming on to in a moment, that issue actually arose between Deutsche Bank and Mr Vik, and Deutsche Bank lost on it, as I shall come to show. There is some sort of effort in the footnote comment which Deutsche Bank added to the authorities by reason of the Connecticut judgment being included in the list of authorities. There are arguments both ways as to whether it should be or shouldn't be. It's always been in the authorities.
It's not really an authority, is it?
It is, in a sense, no more and no less an authority than the trial judgment for the purposes of this hearing, because I would immediately accept that there isn't a legal proposition contained in either of those judgments which the court would need to determine as a matter of law between the parties. And so obviously we accept that, and there have been various issues in relation to that, and I obviously apologise for the length of the authorities' bundles, both as to number and as to the
It would be very hard to decide an appeal on a question of fact without 6 bundles of authorities.
My Lord, with respect, we couldn't agree with you more. That our certification is in a slightly different form, as your Lordship may or may not have seen. anyway, the short point is that the Connecticut decision was not in the bundles of the documents for the court. It went into the authorities bundle as it had done below. There is, and there was below, an argument about whether the Connecticut judgment gives rise to an issue estoppel on this point, which might have been, again, a justification borderline for putting it in the authorities bundle. But the judge below said that she didn't need to decide that. What is clear is that the trial judgment and the findings of Mr. Justice Cook do not give rise to an issue estoppel in favour of Deutsche Bank in relation to that. And so there is a central issue which the court heavily relied upon below, namely Mr. Justice Cook's findings in the trial in relation to Mr. Vik's evidence. And as I say, there is a strong authority to the contrary in the form of direct litigation between Deutsche Bank and Mr. Vik in the form of the Connecticut proceedings, which specifically engaged this issue. And if I can ask you kindly to take that, it's in the authorities bundle at tab 7, which is in the second of the authorities bundle, the trial judgment stretching to about 1.5 bundles. There is a hint of a suggestion that from Deutsche Bank that somehow this isn't worthy of consideration because it's headed post-trial memorandum of decision. The short point on this is the decision of the court. It is signed by the judge at page 66. And it is, and has not been suggested by Deutsche Bank in any sense, not to be an accurate record of the findings that have been made on the issues that arose in the Connecticut court between these parties. And if you turn to page 1, you see that the plaintiff, Deutsche Bank, commenced the action in about December 2013 for a judgment, to enforce a judgment against defendant SHI, rendered in 2013 by an English court, and for the purpose of collecting the judgment against the defendant, Mr. Vik, by piercing the corporate veil of SHI to reach Mr. Vik's assets. And you see that a trial took place over 5 days in November and December 2019. There was live testimony, hundreds of exhibits, transcripts from other proceedings admitted into evidence. And as more fully explained below, the court finds in favour of Mr. Vik because the plaintiff failed to satisfy its burden of proof to justify piercing SHI's corporate veil, and that Mr. Vik diverted SHI's assets with the specific intent of rendering it unable to pay its margin calls to Deutsche Bank. After dealing with other issues and the background, the court turned to address this specific issue at page 58 in the judgment. And towards the top of the page, paragraph number 3, or issue number 3, did Mr. Vik act with specific intent to render SHI unable to pay its margin calls? The answer to this question is the key to the court's decision in the case. Mr. Vik was closely questioned at trial about SHI's transfer of hundreds of millions of dollars to himself, to entities controlled by him or by his father, as initiated between October 8th and 21st, 2008. The court had ample opportunity to observe his testimony and evaluate his credibility. The Connecticut court then goes on to review the various pieces of evidence, following facts are relevant to the decision, And at page 61, in the first full bullet point, in October 2008, there is no question that the financial world was in an unparalleled crisis, was in turmoil. In light of those circumstances, the court finds the most credible explanation of the October transfers is the simplest. Mr. Vik was trying to preserve his wealth for the benefit of his family, primarily by funding a trust with hundreds of millions of dollars. And then, however, one salient fact stands out. Mr. Vik left more than $500 million in SHI's accounts at Deutsche Bank. In fact, he could have credibly believed that he had retained as much as $780 million in SHI's accounts at Deutsche Bank. SHI used this money to cover the first 5 margin calls during the week of October the 13th. And then, after addressing the contentions based upon the English decision, over the page at page 62, Deutsche Bank, the first full paragraph about a third of the way down, Deutsche Bank cannot successfully contend that Mr. Vik acted with specific intent to deprive it of funds when he initiated the October transfers at a time when neither he nor Deutsche Bank knew the extent of the losses that were eventually calculated. Ultimately, Mr. Vik's purpose in directing the transfers is irrelevant to the decisive issue in this case, considering that he actually reserved over $500 million to cover SHI's unspecified debts to Deutsche Bank, if not as much as 780. This was not an unreasonable action, given what he knew at the time. And then at the bullet point at the bottom, the court does not find fraud or deceit or illicit conduct in what Mr. Vik did, i.e. distributing approximately $900 million of SHI's assets when he credibly believed they totaled at least $1.65 billion and had no reason to believe the remainder of approximately $750 million would be inadequate to cover any debt to Deutsche Bank. The honest though mistaken belief that he has a right to do so will defeat specific intent. And then over the top of the page, in fact, the $250 to $280 million which Mr. Vik had reason to believe would be left in the Deutsche Bank accounts after payment of the $511 million in margin calls compares favourably to the amount of $234 million found owing by the English court. By reason of the foregoing, the court finds that Deutsche Bank has not satisfied its burden of proof that in making the October transfers, Mr. Vik acted with the specific intent of depriving SHI of its ability to satisfy its margin calls to Deutsche Bank.
Does the court explain what the standard of proof which the bank was required to discharge was? Was it balance probabilities, beyond reasonable doubt, or something else?
It doesn't in terms specify it, but I have no basis to suggest to you that it was beyond reasonable doubt rather than the normal civil standard. But the ultimate point is that the court charged with the issue as to whether the transfers of the assets were indeed with dishonest intent in a case which was actually between the parties before the court today, between Deutsche Bank and Mr. Vik, came to the conclusion which we have seen there. And we did argue below that it gives rise to issue estoppel. Ultimately, it's issue estoppel on a point of credibility. So it doesn't take you to an ultimate decision, obviously, on a point which the court has to decide. But nevertheless, set against the approach which the court adopted and which Deutsche Bank urged and continues to urge before this court, essentially to start with the proposition starkly stated in their first paragraph as to the dishonesty of my client, the fact remains this issue was foursquare dealt with in a court proceeding. Both sides had full opportunity to marshal the relevant evidence that they wished to do in order to have the issue addressed, and it has been decided adverse to them.
Well, I can understand the point that the first few pages of Ms. Delaney's skeleton appear to be calculated to poison the court's mind before we get to the point. That's a submission that you've made. I've perhaps put it a bit higher than you did, but there we are. But once issue estoppel falls away, and you're not pursuing that in this court, what is the relevance of the Connecticut judgment? Now, I can understand a submission that the court needs to make up, Mrs. Justice Moulder needs to make up her own mind on the evidence at the committal hearing, and that she shouldn't be influenced by the decision of Mr. Justice Cook or the Connecticut findings. And I suppose I can understand a submission that she is entitled to have regard to those matters, in which case one might think that it's for her to decide whether she gives more weight to Mr. Justice Cook or to the judge in Connecticut. But I'm not sure you can have it both ways.
What we're concerned about is that, with respect, it's been had both ways against us. Because what in effect has happened is that the judgment of Mr. Justice Cook, which for the reasons that we've identified, should not have been, for these purposes, adduced before the court as relevant to the question of whether Mr. Vik is or is not an honest witness, has been adduced. And nevertheless, the Connecticut judgment has in effect been sidelined. And so we do say you can't have it both ways. We're not trying to have it both ways. We are trying to explain why the learned judge can't simply rely upon the judgment of Mr. Justice Cook as in some way relevant and admissible findings in relation to the honesty of Mr. Vik in relation to the transactions which were performed, or in relation to the findings in relation to the, or as it were, to bring over prior findings to the civil standard of proof into the criminal context beyond. And so all we say in relation to that is that the Deutsche Bank can't have it both ways, and with respect to her ladyship, the court can't have it both ways. We say that neither should have been relied upon, but if she was going to rely upon anything, she should have relied also upon the Connecticut judgment, which actually was between the parties to this dispute and was on the very issue involved in this dispute.
Can I, in answer to an earlier question, my lords, as to what the standard of proof applied in Connecticut was, refer you to page 43, where there seems to have been a dispute where Deutsche Bank argued that it was the ordinary civil standard with preponderance of evidence, what I think we would call balance of probability, whereas Mr. Vik was arguing for a higher standard, what was called clear and convincing evidence, and as I read it, the judge preferred Deutsche Bank's submission, so it's decided on the preponderance of evidence or balance of probability.
My lord, yes, quite right. I'm sorry, but in the same way that there's been all the debate laid to rest now as to what is the required standard of proof in civil proceedings where fraud is alleged, sort of Hornell and Neuberger sort of point, which is ultimately it's the civil standard of proof, but the more unlikely the proposition that is being contended for, the higher the level of proof that must be adduced in order to satisfy it. Dishonesty is not ordinarily to be assumed, and therefore if you have an otherwise honest person, the higher the standard of proof, the higher the level of evidence required in order to come over the threshold of the civil standard of proof. And that seemed to be the same sort of debate that was taking place in Connecticut, rather than as between the civil and the criminal standard. But in either event, the net result was that the Connecticut court found that the Deutsche Bank had failed even at the civil standard of proof to establish its case. So that even at the lowest possible level, whether civil with or without the dishonesty bells or the criminal, the lowest level was determined by the court as applicable. I'm grateful. And without taking too much time on the introductory paragraphs of the Deutsche Bank skeleton, which have been neatly characterized by the court, paragraph 5 of that is neither fair nor accurate, either in suggesting that Mr Vik took ever more steps to put SHI's assets out of reach and obstruct recovery by Deutsche Bank. What Mr Justice Cook found was that Mr Vik could have taken steps to return the assets to SHI. He did not determine, and nobody has determined, that Mr Vik was under any legal obligation to do so. Deutsche Bank do not cross-reference any evidence as to the alleged ever more steps to put SHI's assets out of reach until you get, in their paragraph, to the Part 71. But whether Mr Vik did wrong in the context of Part 71 is precisely the issue that's before this court. So that's the bootstrapped point, that effectively they say took ever more steps and the Part 71 order was made and Mr Vik failed to provide and so on. But that begs the very question that is the subject of this appeal. And so again, it's significantly overstated in respect to the position against Mr Vik. And so we would urge the court not to be distracted by what in radar terms might be described as noise. And we respectfully suggest that Mrs. Justice Moulder was indeed distracted by the prejudice for the reasons we'll come on to explain. The other point that I wanted to touch on in relation to Deutsche Bank's skeleton at paragraph 6 and 33, which I anticipate will not be that much interest to the court, and I'll take it quite quickly. It is said that Mr Vik is criticised for engineering delay and playing games. Just briefly, he has not been without success in the litigation, a point ignored altogether by Deutsche Bank. No court has described his unsuccessful legal challenges as abusive. On the contrary, he has been given permission to appeal on various occasions, and on other occasions he's admittedly unsuccessfully, but not with criticism of his conduct in seeking permission to appeal, been refused permission to appeal, and that is an ordinary incident of litigation.
What is the success that he's had in the litigation?
Well, for example, the application, the first application, which is mischaracterized by Deutsche Bank for permission to serve out in hearing before Mr. Justice Tier. That was an application before Mr. Justice Tier for permission to serve out, and Deutsche Bank lost that application. We were right to challenge that. It was a perfectly legitimate challenge to the way in which the claimant was pressing forward with his litigation, and Mr. Justice Tier held in our favour that we were right to have challenged it. He rejected it. The Deutsche Bank then made a different application saying, well, actually, we don't need permission to appeal, permission to serve out, and it was that on which they were ultimately successful, and on which we got permission to appeal, and the appeal was rejected. But these are not valid criticisms. They're not the proper foundation for a statement that my client is engineering delay or playing games in the litigation. And inevitably, some parts of the time taken have been down to the time it has taken Deutsche Bank to complete such matters as formulating and issuing its contempt application, and then in applying for permission to serve out, which I've already covered with my Lord or Justice Nugee, which they lost, and that of course took time as well. And in relation to the strikeout application, which my clients made in relation to the contempt proceedings, which was heard before Mrs. Justice Cockerell, again, attempts were made by Deutsche Bank to suggest that this was somehow an indication of game playing and time wasting and so on, because we'd left it until when we did to make the application. Mrs. Justice Cockerell rejected that approach at paragraph 47 to 48 of her judgment. I don't invite the court to turn it up, but it's at A6, tab 6 of the authorities, or tab 6 of the authorities bundle, and she rejected it on the basis that it was a perfectly proper approach, and indeed driven by the court, to say that an application to strike out should ordinarily be dealt with at trial, on the basis that it is at trial that the court is in the best position to determine that application. And the reason why the application to strike out was brought when it was earlier, rather than having been brought even later at the trial, was because the Deutsche Bank amendment application had raised many of the same points which would have been raised in any event on the strikeout application at the hearing, and therefore inevitably once the amendment application was brought, so the points in relation to the strikeout were brought, and hence the strikeout application being brought, if anything, earlier. So again, the prejudicial slant, this time in relation to the conduct of the litigation with which Deutsche Bank seeks to damage Mr Vik in proceedings where he is at risk of imprisonment, is both wrong and unfair, and falls away as it did before Mrs Justice Cochrane. Ultimately, though, we say that historic findings are legally of little or no weight in any proceedings, but particularly so in subsequent criminal or quasi-criminal proceedings, such as proceedings for contempt. We've addressed this in our skeleton argument at paragraph 36. In with reference to Bairstow, again, a case which I anticipate the court is very familiar with and I wasn't proposing to go to. The position obviously is more acute in criminal proceedings for the reasons that we've indicated, and the committal context is in that sense comparable to criminal proceedings. Obviously the relevant standard of proof, the requirement of a high standard of procedural fairness, the requirement of clarity of charges, and therefore, as we've pointed out in paragraph 38, if one is going to rely upon previous findings of some kind, one has to look very carefully at what one is using them for and how one is using them. Because the fact that a previous finding of untruthfulness is somehow to be brought forward as similar fact or bad character evidence, well, absent some enhanced relevance or special probative value outweighing by a considerable margin its potential to cause prejudice, all that it does is, as we say, cause prejudice. It isn't a finding that's been established to the relevant criminal standard, and it takes you no further. Alternatively, as we set out at 38.2, if there is a prior lie before trial or in the course of evidence, then the court should be sure that it was a deliberate untruth, the lie related to a significant issue in the trial, and was not told for some other reason that does not point to the defendant's guilt overall, and we cite Lucas and Lacotte Consulting.
But the Lucas direction doesn't apply in this type of scenario, Mr. Matthews. Lucas is all to do with whether or not there is another way to explain what happened other than guilt of a criminal charge. It doesn't translate into this context.
Well, I don't propose to spend a lot of time on it. All I'm suggesting...
It's not your best point.
I'm grateful for that. All I'm suggesting is that any use of any prior findings has to be done with extreme caution because of the importance of understanding precisely what you are relying upon it for. And if you are relying upon it as a finding that this person is generally not to be believed, then it's a very dangerous path for a judge to go down because it hasn't been previously tested to the criminal standard. And now in a committal trial, it is being tested to a criminal standard, and therefore different standards having been applied shouldn't be relying upon the first judgment. If it's being relied upon for, in effect, some sort of similar fact, saying, well, he's done this sort of thing before, therefore I can understand he'd do it again. Again, you've got to be very careful because the fact that he's done it before has not been established to the criminal standard, which is the relevant one for the purposes of the contempt hearing. So, and we say that the position, therefore, on this is that the judge should not have given weight to those findings of Mr. Justice Cook, let alone when set against the fact that you have the findings of the Connecticut court dealing with the specific incident in relation to the transfer of assets. And so far as that aspect was being considered, then that is the finding that the judge should have relied upon. If either, that is our primary point, that neither, because of the standard of proof being applied in relation to these, neither should have assisted. Now,
can I be sure I understand what you've said more than once that you need to be very cautious or give little weight to, but it's not your submission that these findings are of no weight at all, wholly inadmissible, and should never have been before the judge. I think it was agreed that Mr. Justice Cook's judgment was admissible.
It was agreed that the judgment was admissible.
Right.
But you then have to be very careful which findings of the judge are used for what purpose.
Yes, I see.
And that is where we say the judge went wrong in relation to her reliance upon the findings of Mr. Justice Cook. She effectively incorporated the findings to the civil standard in relation to an oral agreement into her assessment of general credibility, which she then has as a fundamental anchor for her analysis to the criminal standard in the contempt proceedings. And that's a leap which we say you can't make.
I understand the point that Mr. Justice Cook was hearing ordinary civil proceedings in which the standard of proof is the balance of probabilities. When a judge is reaching a conclusion that a witness has lied in the witness box to him, in not dissimilar fashion to a point you were making earlier, on the whole, you don't start with the assumption that people tell lies, and you need to be quite satisfied that someone has lied to you before you make that finding in a judgment. And judges are careful before they make those findings. And so, is that not something that Mrs. Justice Moulder can place some weight on? Although, as you say, one has to be cautious about how much weight you place on it.
Our primary position is that she shouldn't have placed any weight on it, on the basis that it is not although of course judges are careful in making their decision as to dishonesty or lying of a witness, ultimately it was not a decision to the criminal standard in relation to that issue. It is simply in the Hollington and Hewthorne analysis the decision of another tribunal on another issue to a different standard of proof, and therefore not something that this court, the committal or contempt court, should safely rely on. There may be something of a different approach where the same judge is dealing with the contempt, and the judge has heard and formed their own view in relation to the specific allegation which underlies the contempt, and then goes on to deal with the contempt proceedings and is satisfied to the criminal standard of proof. But in a sense, they're not simply adopting their previous decision, they are coming to the decision in the context of the committal hearing, conscious of the criminal standard of proof that is required, and assessing whether the decision that they have made before satisfies that, whether there are other factors that might have been taken into account, and so on. So obviously that is a slightly different position, but that is not the position that we're concerned with here, because of course there was a completely different judge who dealt with the hearing below, who weighed the evidence below, who formed his own conclusions. And Mrs. Justice Moulder, as in effect she directs herself in the judgment, but with respect then doesn't actually do, says she has to come to her own decision on the basis of the evidence in the case. And that's one of the reasons why she rejects the Connecticut judgment as having something that can assist her. But in practice, what she then does is, in practice, rely upon Mr. Justice Cook's finding as one of the relevant factors.
Suppose she came to her own conclusion, as she says she does, on the evidence in the case, and reaches the conclusion that Mr. Vik was not a man whose evidence she was disposed to believe. Can she not support a conclusion she's come to on her own assessment by the fact that, what is more, Mr. Justice Cook didn't believe him when he gave evidence before him either.
That is a very dangerous path, I would respectfully submit, because it is not safe in a committal context where a prison sentence lies as the ultimate penalty, the quasi-criminal nature of it, to simply adopt a finding of another judge on a different burden of proof with different evidence, a decision that that judge came to. It may even have
that
been...
wasn't quite my question. She doesn't say, the reason I think Mr. Vik is lying to me is because I know he lied to Mr. Justice Cook. What she says is, I've formed my own assessment. I think he's lying. And I note that Mr. Justice Cook also thought he was lying when he gave evidence before him. Now, is there anything wrong with that?
Well, the question is, what is the function of that additional paragraph?
Might be said to be a reality check, Mr. Matthews.
But why is it in any sense?
Because if another judge has found him to be an honest witness, you might then start revising your own views, which you formed independently. But if the other judge has said that he is satisfied to whatever standard it was that he was lied to in the past, it's a reinforcement of your own finding.
Well, I can say no more than reiterate what I said to Lord Justice Nugee, that it's a dangerous path for a judge to tread, making that crossover. I can understand that you might do that in civil proceedings, although still you might have to overcome Hollington and Hewthorne as to whether it's a legitimate approach to take. But nevertheless, you cannot do it when you're making that transition from a civil procedure with a different judge has heard whatever evidence he has. You yourself might, faced with the same evidence, have come to a different conclusion. You don't know. And then what is the effect? Why are you fortified? If you yourself had reviewed that evidence, you might have come to a different conclusion from the judge.
Well, that begs the question of what you were doing allowing this judgment to be in the bundle in the first place, because what relevance does it have at all?
Well, it was inevitably part of the way in which the factual aspects of the case, as to the background, the procedural context and so on, had been addressed, but it was not there in order that reliance could be placed upon particular findings in relation to Mr. Vik, who was not a party to those proceedings.
Can I ask you something else? You've referred more than once to Hollington and Hewthorne, which I understand to be authority for the proposition. You can't prove a fact before Judge B by showing that you proved that fact in different proceedings before Judge A. That doesn't prove the fact.
My lord, yes.
But these are findings of credibility.
Yes.
My understanding of the law, tell me if I'm wrong, is that one can cross-examine as to credit and ask a witness, subject to statutory restrictions in criminal proceedings which don't apply here, have you been disbelieved on your oath before? But that's a legitimate question, isn't it?
Yes.
Isn't that the sort of question that counsel frequently used to ask defendants? Subject to
I have to say, it's not a question I have ever heard asked. It's a question that I will be asking in future, and I'm sure it's a very good one. But whether it's legally relevant or admissible is the more difficult path, because in order for the judge to ascertain the position in relation to that, it would have to investigate the circumstances in which that occurred. So, for example, if it's a criminal trial, you get in before a jury, you get into the difficulty as to why and in what circumstances, if you don't know the answer to that, a conviction has been found, because you don't have a reasoned judgment. So the mere fact of having been disbelieved opens the door rather than closes it and decides it for you. So, our primary position would be that you are not supposed to rely in finding to a criminal standard on committal proceedings that somebody has is generally not credible because somebody else to a different standard has found that they were not telling the truth in that case.
Okay. Thank you.
I had the question asked in a trial once, and the witness gave the answer yes, but the judge was wrong, and we just went round in circles. So you might want to think about whether you're really going to adopt it.
Well, I mean, that is, yes, as a future line of questioning, I'm grateful, yes. I mean, that's sort of underlies my answer. I mean, it opens the can of worms rather than actually shedding much light on it. I have developed this in some detail in our skeleton argument, and I want to come on in a little detail to the factual aspect of the second point. So we've dealt with it in our skeleton argument at paragraphs 42 to 53 in some detail, the where and how the learned judge placed reliance on the judgment of Mr. Justice Cook, and we entirely recognise the directions that Lord Justice Mayles has already flagged up at the earlier part of the judgment, which the Mrs. Justice Moulder advanced. But if one looks at how it's addressed, for example, quite a bit later in the judgment, for example, in relation to the universal point in the judgment at paragraph 326, which is at page 258 in the core bundle.
Well, you said, I think, for example, but am I right, this is the only example you give in your skeleton of where she did this?
It is the only example we give in our skeleton.
Did she do it anywhere else?
I'll come back to that if I might. At 326, she says that submission ignores a number of matters. First, and right up central, the court's assessment of the credibility of Mr. Vik's evidence generally. So that's the starting point. And we say that is in effect. You can't say anything without being disbelieved. 327.
So if she put that at number 5 instead of number 1, where does that get you?
I wouldn't be any happier, my lady, but I'm more unhappy this way round.
Yeah.
I wouldn't say it was a correct approach because of our criticisms of the approach to general credibility. But I don't want to get back into the earlier point.
Why does the fact that she happens to have labelled it number 1 give it any priority over the other factors that she's listed? It doesn't necessarily mean that because you itemise certain factors in a particular order that you're putting more weight on the first than on the last. Certainly not when I write a judgment, it doesn't.
My lady, of course that's right. The fact remains, the first point the judge comes to is the general credibility. And it inevitably suggests that Mr. Vik's evidence and all the other evidence is being assessed by reference to the position of Mr. Vik already being on the back foot because of the first point.
But the context of this is paragraph 325, where the submission, where Mr. Vik is disavowing a document which he himself has signed. Well, you've got to see, and the however in 326 is following on from that.
Well, it's in the context of deciding whether Mr. Vik is to be believed, in effect, when he says, I sign documents as they're put in front of me without checking their contents. Ironically, item 1 of her list of reasons for disbelieving him ought to have induced her to believing him. Because if you form a positive view of somebody's credibility, it actually makes it the less likely that he's going to sign a document which may contain an untruth without reading it carefully. But I mean, I don't want to get too deeply into that because there is a separate point which the judge effectively, everything Mr. Vik says is used against him one way or the other. And I'll come back to it in the context of another document where if there's an inconsistency between two documents or even within a document, the judge adopts the reading or the meaning which is hostile or adverse to Mr. Vik rather than the alternative which would have been favourable to him. And is it so odd that a busy, successful businessman who has people who do documents for him signs the documents that are put in front of him without reading them carefully. Maybe, and the submission I made to the judge, maybe one can criticise somebody for their business practice in taking not sufficient care. Maybe other people would say, if I spent all my time reading the documents that were put in front of me, I'd never have a business. That there are different ways of looking at that, and it's not necessarily a fair criticism of somebody's honesty that they say that they have a business practice. But if one then moves on to 327, having dealt with that, then the judge says the court is also entitled to have regard to the findings of Mr. Justice Cook in support of the view that the court has reached independently of Mr. Vik's credibility. Mr. Justice Cook found that Mr. Vik's evidence about these agreements, however, bears all the hallmarks of being fabricated in order to make a case, and even in the absence of evidence from Mr. Moulder rejected it. At 386, Mr. Justice Cook found that Mr. Vik had fabricated an agreement. I conclude that what Mr. Vik has done is to seize upon the bank's failure to effect margin calculations. And then at 329, whilst noting that Mr. Justice Cook was not making findings to the criminal standard, this court is entitled to take into account that evidence in assessing the credibility of Mr. Vik's evidence to this court and the genuineness of the sale agreement. And then repeats the general mantra in Ablyazov from Shepard, that you don't have to prove every fact to the criminal standard of proof. But that's not the relevant point. But the relevant point that is being addressed here is the extent to which it is legitimate in coming to a conclusion about somebody's credibility to take into a general credibility and then to hold it against them in relation to each of the individual items, a decision of another judge on another matter to a different standard of proof. That is why we say that it is paragraph 44 of our skeleton argument. It is not relevant evidence, still less valuable evidence, that Mr. Vik acted dishonestly in the manner found by Mr. Justice Cook when Mrs. Justice Moulder was coming on to assess different allegations on different evidence and in a different context. But by contrast, obviously, the prejudicial value of that is substantial. As I say, I'm going to proceed on the basis that the court is familiar with what we've set out in this section of our skeleton argument. We don't, contrary to the suggestion of the Deutsche Bank, suggest that the decisions of Al-Giobri and Helene, or that it should actually be Bailey and Bailey, but the parties are, for a slightly odd reason, referring to it as Helene, but it is the one in the bundles referred to as Bailey and Bailey. The position is that we don't necessarily, and we don't say that those cases were wrongly decided. They are different, but it is a different approach that should have been adopted by the learned judge in this case. But what I want to do now is to come on to just a moment to the second point. But essentially, therefore, we say that the judge should not have attached any weight to the previous finding of Mr. Justice Cook in relation to either her conclusion on general credibility or specific on specific issues. But even if she did, the weight that she gave it simply couldn't properly be borne with the conclusions that she draws. And one sees that she definitely did take it into account in 327 and 329 of her judgment. And again, if the court goes on to 341, when the conclusion that the judge reaches, beginning with accordingly, thus demonstrating, as one would expect, that she has encompassed into her conclusion at 341 all of the matters that she's recited before, including the reliance upon the decision of Mr. Justice Cook.
Are you saying that by taking those matters into account when she shouldn't have done, that taints her conclusion, even if all the other matters that she took into account would have supported it?
Yes, we do, individually.
You have to, don't you?
Individually and cumulatively, we make these 3 points. But we say that not only you can't unscramble from the judge's analysis the significance, but even if you seek to do that exercise, the next one that I want to come on to is the more serious and
That's quite a bold submission, Mr. Matthews, because let's suppose that you have a case, not this one, a hypothetical case, where the judge has a wealth of contemporaneous evidence that points towards a witness saying something that is untruthful. And that evidence in and of itself would support a finding to the criminal standard that he was lying. Surely it can't be right that if that were the sort of case that one was dealing with, that the judge's finding that he's telling a lie is somehow tainted by the fact that the judge, he or she, has also taken into account something which is wholly irrelevant on your submission, which is that another judge has found he was a liar on a previous occasion.
the difficulty with, or the difference between that situation and ours, is that in our situation, the judge has laid foursquare centre her decision on credibility as a key foundation for her assessment of the evidence.
Yeah.
And that's what goes fundamentally to...
You say it taints all the other, it skews the evaluation of everything else.
It does.
Right.
Exactly.
Yeah.
I was going to turn next to what we have referred to as the abandoned allegations. I don't know at what time it's convenient to the court if a break is to be taken.
I wasn't aware we were going to have a break. Is that needed?
I had understood that I've simply been told that there is an off-site recorder, transcript writer, who I'd understood needed a break, but if I'm the only person under that impression, I'm more than happy to crack on.
That's the norm with Opus 2, isn't it? Well, I just worry about this other recorder.
All right. Well, if there might be somebody who does need one, all right. Well, we'll take just 5 minutes, but perhaps if not immediately, you could investigate and see whether that is going to be necessary. I mean, with all the resources in this case, one might think that something could be done to enable us to carry on.
I've taken very brief instructions now and had confirmation that my understanding as I gave it to your lordship is correct. But whether something can be done to avert that need for this afternoon or for tomorrow and so on, I will make inquiries.
Yes. All right, well, we'll take 5 minutes.
Votes raised. Just to let you know, the recording will stay on for 5 minutes.
Thank you.
Courts rose.
Well, if it is convenient, Mr. Matthews, we're content to take a short break in the middle of the morning and the afternoon, if that's going to fit in with everybody's arrangements.
I'm very grateful, my lord. We are taking instructions as to whether that can be avoided. But I'm grateful. I was going to turn next to the second major ground in relation to the credibility, which is that in relation to the what are loosely referred to as the abandoned allegations.
Yes.
In other words, the findings on credibility in relation to those allegations which were not the grounds of contempt. And we turn to that in our skeleton at paragraph 55 and deal with it in paragraphs 55 to 67. And we address two particular aspects of that. Firstly, the findings of the judge in relation to Carlyle, one of the partnership interests that SHI had and which was transferred to a third party, and namely, come back to it, but secondly, the right and interests transferred to SAREC. I should point out, as we do at the beginning of paragraph 55, that the judge raises three matters in this context. We point that out. We haven't dealt in detail in our skeleton with the first of the matters, and that is really because in our respectful submission it is so trivial that it's difficult to credit the judge really having taken much significance from it, and she doesn't appear to have made much reference or reliance to it subsequently. That's the bit that's dealt with in the judgment at paragraphs 76 to 78. That is where the judge says, on occasion when faced with a contemporaneous document which Mr Vik understood was adverse to his case, he resorted to giving evidence which was clearly absurd. And then the learned judge refers to an email from Mr Johansson to Mr Cantasaria of Devon Park after SHI had purportedly divested itself of its VBI's interest in response to an email in which Cantasaria had objected to endless emails and calls. And just to put it in context, your lordships will probably, and ladyship will probably be fully aware of this, but the point being made is that the Carlisle interest, the Devon Park interest was supposed to have been, another partnership interest was supposed to have been transferred, it's an investment in a biochemical or biomedical fund, was supposed to have been transferred away under the sale agreement. I'll come back to this in the context of the Devon Park specific issue, but transferred away from SHI in 2012 under the terms of the sale agreement to VBI, and then in 2014, pursuant to instructions from VBI, because it hadn't actually been legally transferred across to VBI, in 2014, VBI gave instructions that it be transferred to Universal. And then after 2014, reliance was placed upon some documents subsequent to 2014 in relation to the exchanges between Mr. Johansson and Devon Park in relation to that transfer to Universal. And the issue essentially was, what was Mr. Johansson doing getting involved in that if SHI or Mr. Vik had no interest in the Devon Park holding after 2012, let alone 2014. And I mean, that passage is then, which is dealt with at 76 to 78, it is the judge's assessment of some of Mr. Vik's evidence in relation to that. And in this exchanges cited, Mr. Vik was being asked to speculate as to what he thought Mr. Johansson meant by words used in an email to which Mr. Vik was not a party. And be that as it may, the conclusion of the judge seems to be that Mr. Vik invented an absurd construction of the email because the wording of the email was inconsistent in some way with his evidence. Even if it was appropriate for him to be asked to speculate on the meaning of someone else's communication to which he was not a party, in reality, it's difficult to see what the inconsistency is supposed to be. It's identified at paragraph 78 of the judgment, where the judge says it was an example of Mr. Vik trying to explain away contemporaneous documentation which has now come to light, when he was pressed on his first explanation that Mr. Johansson was helping Universal to get distributions on the basis that it was inconsistent with his earlier evidence that Mr. Johansson was facilitating the transfer, persisted in a response which was clearly absurd. Well, it's quite difficult to see what the inconsistency is supposed to be, that somehow there is an inconsistency between helping Universal to get to the dividends and facilitating the transfer. This, of course, was post-2014, when the interest in Devon Park should have been effectively transferred at the request of VBI to Universal, who should therefore have been recognised by Devon Park as entitled to the interest and therefore entitled to the dividend. And there is no difference, obviously, between the two elements of the exercise. What SHI was responsible for doing under the terms of its 2012 agreement was transferring the asset which it had sold to VBI, to the order of VBI, which was to Universal. VBI said, we want you to transfer it to Universal in 2014, and that was not effectively achieved because Devon Park was refusing to recognise it. So it's a little difficult to see what the inconsistency was, because they seem to be essentially the same point, that the achievement of the transfer had to be achieved in order to ensure that the dividend was then paid out to the transferee, namely Universal. And therefore, as I say, it remains something of a mystery as to what the supposed inconsistency is supposed to be, from which Mr Vik was trying to escape, supposedly, when he was asked to speculate as to what somebody else's email to somebody else might have meant. So it's not much of a ground, but in fairness to the learned judge, she doesn't seem to have based much on it, or not specifically, in the same way as she definitely did in relation to some of the points I'm coming on to now. Turning back to the two main findings, which we identify in paragraph 55 of the skeleton, to which the judge clearly did wrongly attach significant weight, we say that the judge was wrong in principle to investigate and make findings, let alone significant findings, on these abandoned allegations, or allegations not advanced as grounds of contempt. We deal with that at paragraphs 56 and 57. The person accused of contempt is entitled to know what he has to answer, what he has to adduce evidence in relation to, and insofar as it is the position that allegations are then dropped, or not the allegations that the defendant has to deal with, it's not fair that an investigation is then carried out in relation to these matters and relied upon centrally. And the allegations about Sarek and Carlisle had originally been advanced, but subsequently were abandoned or not treated as founding the allegations of contempt. And we deal with that in paragraphs 58 to 60 and 62 to 63 of our skeleton.
Do you have a reference, please, to the letter of 17th December 2021? I thought I'd seen it, but then when I looked for it, I couldn't find it. So I'd be grateful.
I will come to your lordship. That's the abandonment of the...
Exactly.
Yes. I will. What I'm going to take your lordship to is the crossing out in the application notice itself to show what went, but I will definitely find that.
All right, I'd be grateful.
Reference. We've got it. Thank you. And the position in relation to Sarek was in a sense subsidiary to those relating to the partnership interests in Carlisle, because the issue in relation to Sarek was that partnership interests had been transferred to Sarek, and the question is who is the owner of Sarek. But I'm going to therefore start with the transfer of or the allegations in relation to the transfer of the interest, or the ownership of the interest, which had been abandoned.
Can I just check my understanding of another point, which is that at a time when this ground A4, I think it was in, Mr Vik prepared an affidavit, which was his response to the whole charges of contempt against him, which he served but did not formally deploy. Is that right? So he was effectively preserving his right to silence.
Yes, he was in limbo.
Yeah, but did that affidavit, in its initial version, include his response, whatever it was, to the A4 ground of contempt?
It did initially, yes.
And then when A4 fell away, that bit was struck out of the affidavit, which was then used at the hearing. Is that how it worked?
Yes.
Yeah, okay, I'm grateful.
But obviously, your lordship and ladyship will not be unaware of the fact that just because that is the evidence that was crystallised then doesn't mean that further evidence might not have been applied to be admitted subsequently. But I'm going to come
I understand. I just want to make sure I understood the chronology correctly.
Yes. And the withdrawal of the allegations, if we can just take the core bundle at tab 11, which contains the application And at page 306, sorry, I should start at 305. The allegation at A towards the bottom of the page is that Mr Vik failed to comply with paragraph 1 of the Tier J order, in that he deliberately failed to provide information about SHI's means or other information needed to enforce the judgment order. In particular, Mr Vik intentionally failed to provide truthful and or complete information regarding his knowledge in relation to, and then over the page at Roman 4, the transfers of SHI's interests in certain private equity funds, the partnership interests, and that includes Carlyle and Brighton. And then if we go on to the schedule.
Well, we'd better notice, hadn't we, that what they were giving with one hand in A4, they were putting back, at least to some extent, with the other in B1C,
Well,
where Carlyle and Brighton come in relation to failure to produce documents.
electronic documents. They do, that is correct.
Yeah, okay.
But that is a very different matter from the allegation in relation to false testimony in relation to the transfers of the assets, which is the point that was focused on. And again, at paragraph, at page 311, ground A4, having been deleted, that took out the allegations which you can see in red and crossed out in red. At the Vik cross-examination hearing, Mr Vik gave evidence, the substance of which was that in September 2008, SHI had entered into agreements to transfer or dispose of its interests in Carlyle and so on to Delagoa in relation to Carlyle and to Sarek in relation to the Wrighton partnerships. And the substance of his evidence again was set out at 8. That there was no trading after November 2008 in the Carlyle partnerships because Mr. SHI had already disposed of these interests, and it is said at 9 that that was deliberately false, as he knew he did not enter, SHI did not enter into any agreements with Delagoa and the general partners until after September 2008, didn't enter into any agreements with Sarek and the general partners of the Wrighton funds, and the transfers of SHI's interests in the Carlyle partnerships and Wrighton partnerships were not effective until after September 2008, and the written deeds of assignment and adherence, and so on. And then the evidence in support of those transactions was struck out, and at paragraph 10, Mr Vik gave evidence, the substance of which was that he thought he'd ceased to have any interest in Delagoa in 2008, having at that time transferred to it to his father. This evidence was deliberately false, in that Mr Vik continued to own Delagoa, and that too went together with the relevant paragraphs of the Hart affidavit. I didn't hop up and down at the hearing before. This is Justice Moulder. I did make a couple of interventions to suggest that these lines of questioning were not appropriate, and we've given you references to those. Just for your note, it's in the transcript, day 7, pages 92 to 95, which is in the supplementary bundle 2, tab 12, at page 429, and then again in the day 7 of the transcript at page 106, which is in the supplementary bundle tab 5 at pages 204 and again at 207. And these points were also dealt with in oral closings and in our skeleton below, and we have the cross-reference to the core supplementary bundle for the reference to the oral closings at tab 9, pages 68 to 69. But what is essential for our purposes is that the questions were nevertheless put in relation to these abandoned allegations. The judge also made important findings based on the answers in relation to those issues, where we say the relevant evidence was not before her properly to enable her to evaluate the truth or otherwise of the answers. And we have developed that in our skeleton at paragraphs 61 and 64 to 67. And so the second key flaw, we say, was in this respect. And turning to Carlyle, the judge in her judgment at paragraph 86 recorded the fact that the documents at issue, so at page 202 of the core, the ladyship says, finally, I have regard to the evidence concerning the deeds of transfer of the partnership interests. Whilst the particular documents at issue are not now the subject matter of the alleged false statements in these committal proceedings, it is a matter which is relevant to the credibility of Mr Vik's evidence, in particular because, in relation to certain of the specific allegations on the committal application, the genuineness of other documents are in issue, notably, of course, as your lordship and ladyship will be aware, the 2012 sale agreement. And so what the learned judge is doing is saying that even though these allegations, which I'm now going to consider, were not the subject matter of alleged contempt, nevertheless I'm going to form a view in relation to those, which is then going to impact upon the view that I'm going to take on those matters which are still an issue. So it's an open and clear statement of an intention to use findings in relation to these other matters when assessing the evidence in relation to matters that were in issue. And the judge's focus on the abandoned allegations gave rise, we say, to two significant errors in the judge's reasoning in relation to the Carlyle transfer deeds, amounting to misunderstandings of the evidence, conclusions which the evidence could not on any view support, or otherwise errors of reasoning, and therefore undermining the approach taken. And if we look at paragraphs 87 to 95 of the judgment, the judge considered extremely important in the analysis of Mr Vik's credibility her conclusion that he had signed the Carlyle document twice. And she addresses it in paragraphs 87 and following. The fact that in October 2015, Mr Vik disclosed 5 purported deeds of transfer. So that's on the eve of the Part 71 cross-examination, and in compliance with Mr Vik's obligations to produce documents in relation to the assets of SHI. And the version disclosed had the date of 26 September 2008 written in by hand, and an effective date also written in by hand of 26 September. On its face, it was executed by Mr Vik for SHI in the presence of his wife, and executed for Delagoa Bay, Mr Vik's father's company, by Mr Johansson, again with Mr Vik's wife as witness. Each of these transfers required the consent of the general partner, but the version disclosed did not contain any signature by the general partner. No concealment in relation to that. Subsequently, the bank obtained a Norwich pharmacal order against certain of the general partners in the Carlyle and Wrighton groups. This revealed certain documents that Mr Vik had not disclosed in October 2015. One of those documents was a version of the transfer deeds which, unlike the version disclosed by Mr Vik at the top right-hand corner, had the words execution version, and on the bottom left-hand corner, version 6, whereas the reference on the version that Mr Vik disclosed said version 5. Then the learned judge deals with Mr Vik's evidence in relation to it. He says, I had nothing to do with this, I don't know anything about it. Here it says version 5 or version 6, more than that I don't know. And the point is made, well, you executed the document, so you had something to do with it. Yes, I sign all kinds of things, but I had no knowledge of these things. And that's the point I was making earlier. One might well complain about his business methods in that sense, but it's hardly a finding of dishonesty. Further differences between the versions were that the later version of the deed was dated 2nd of December 2009 and recorded that although the assignor and the assignee had agreed the transfer would be effective as of 26 September 2008, the transfer effective date was treated as being effective as of 30th of September 2009, whereas this text did not appear in the versions Mr Vik disclosed, and finally the versions obtained through the Norwich Pharmacal Order did have the general partner's signature and consent on their signature page, and the same points apply to all the other documents. So they were just a sequence of sets of documents, and one was taken by way of example. Mr Vik denied in cross-examination that he had deliberately disclosed a document to support his argument the transfers had happened in September 2008. He sought to suggest any fault lay with Mr Johansson. What you disclosed as evidence were drafts when somebody had written in conveniently dates in September 2008, and that's all you disclosed. And then he answers, Mr Vik answers, I disclosed what I was given by Mr Johansson, so that was what I was given. And then paragraph 92, very important. Mr Vik's evidence was that he signs documents without reading them and merely disclosed what he was given by Mr Johansson. However, this evidence fails to provide a satisfactory explanation as to why, even if he does not read documents before he signs them, these 5 separate deeds were each signed twice by him. And that's what I need to come back to as the first point in a little bit of detail, i.e. both versions 5 and 6. The explanation that the documents were given to him by Mr Johansson to disclose does not explain how Mr Vik came to sign 5 deeds twice. Mr Vik disclosed the earlier versions of the deeds, and these themselves were amended in manuscript, and the court would therefore have to infer that it was mere chance that he had retained and then disclosed only the earlier versions of each of these deeds with the dates which accord with his case, rather than the later version which is adverse to his case. Paragraph 94, in my view, such an inference is wholly implausible, and there is no explanation for the manuscript amendments other than they must have been made deliberately. Again, important, that's the second aspect, significance of the manuscript amendments. In the circumstances where the later versions have only come to light from third parties, I do not accept any explanation that Mr Vik was unaware of the fact that these documents, which were disclosed by or on his behalf, were not the final versions. I'm sure that this was a deliberate attempt to mislead by his disclosure and his evidence to this court that he did not know anything about the different versions and merely disclosed what he was given by Mr Johansson is a deliberate lie. Whilst this allegation is not before the court on this application, it is highly relevant to the credibility of Mr Vik generally and to the plausibility of arguments put forward concerning Mr Vik's actions. So it's a pervasive finding in this context, avowedly on the part of the judge. The key first point is Mr Vik didn't sign 2 sets of deeds. It's quite clear. I'll come on to show how and how the error occurred. But it is absolutely fundamental. There is only evidence that he signed once, and any conclusion that he signed twice, which, as you've seen, heavily underpins this area, is clearly wrong. Now, the documents which we need to look at for this purpose are in the core supplementary bundle at tabs 20 and 25. And I don't know to what extent the court has hard copies of the bundles. To the extent that the court does, it would be helpful if, as it were, a finger could be kept in each of the 2 tabs, 20 and 25, as the easiest way to review it. That didn't happen below, and the documents were looked at only on the screen and electronically. We also need to take the evidence of Mr Vik from the transcript in relation to this, which is in the 3rd supplementary bundle at tab with me a moment. Sorry, not the third supplemental bundle. It's in the first supplemental bundle. Yes, tab 5. Page 200. Now, if we take up the transcript at internal page 77, line 19, at page 200 of tab 5 of the supplemental bundle, this is where line 19, Mr. Laney says, and let's have a look now at A 4.31. That's the equivalent of tab 25 in your bundle.
Sorry, where are we in the transcript?
Sorry, in the bundle,
page
200.
200, right.
In internal, page 77.
Yes.
Line 19.
Okay, I'm with you.
Thank you, Moulder.
Thank you very much.
Mr. Vik is taken to the document, which is the equivalent of tab 25 in our bundle. So if at this stage one has tab 25 open, it's, the point is made, if we go to the top right-hand corner, you can see the words executed version, which we can indeed see on the top right-hand corner. And that was not on the version you disclosed, was it? Answer, I don't know. And so the witness is then taken at the same time to the document which you have in bundle 20, sorry, tab 20. And indeed it is the case that if you look at the document at tab 20,
we can see that 25 is execution version and version 6, and tab 20 is version 5 and doesn't have execution version. Is that the point you want?
That's the starting point.
Yep.
And then the point is put to Mr. Vik, the one that you disclose is on the left, that's tab 20, and the one that I'm showing you, the execution version, is on the right. And if you can look at the left-hand corner of each of these documents, if you can blow up the left-hand corner of 334 document, and so what then happens is that the bottom left-hand corner of the document is blown up. And if you do that on the document at tab 20, you see in the bottom left-hand corner the last two ciphers on the code number are V5. If we compare it to the other document, so we go to 25, we find that the witness is shown the bottom left-hand corner, and it says V6.
Is the point that pages 203 onwards are taken from V5 and put into V6? Not onwards, just 2 pages. Only 2 pages are taken out and put in. 203 and 204.
My lady, yes. And so what happens, and it's important to see it in the context of the way, because this is part of the problem, that when you, Mr. Vik is looking at these documents, he's not picked up the point you've picked up, but he's not looking at these documents on paper. He's looking at these documents and at the position of the documents where he's shown. So over the page of page 79, you can, it's being put to him, you can see it says version 5 or version 6, and Mr. Vik says, I had nothing to do with it, I really don't know anything about it. You executed these documents, you had something to do with it, yes, I sign all the things and so on. If we go to the version on the right-hand side, we can see the deed is dated the 2nd day of December 2009. So that's version 6 is 2009. And you see that clause 1 records and then recite the various bits relating to 2009. Now, towards the bottom of page 79 of the transcript, this text does not appear in the version you disclosed. If we look at the left-hand document, and if you go to the equivalent page, what we can see is the version you disclosed had handwritten dates and didn't have the text that we see in clause 1 of the executed version. And that's undoubtedly true. If you go on in tab 20 to page 142, this is the reference to the manuscript bit, to which the learned judge also attached great significance. The manuscript on page 142, both at the top, 1/3 of the way down in the recital there, and 2/3 of the way down under clause 1, both have an effective date of the 30th of September 2008. Whereas if you go to the equivalent page in version 6 at page 185 in tab 25, you see that that has been both replaced by the other date, 2009, although clause 1 is now in slightly different form. The partnership, general partners, have agreed to introduce the 26th September 2008 date as the effective transfer date as between assignor and assignee, but they insisted upon the 30th September 2009 as the effective date in relation to the general partner. And so questions are asked in relation to that. And then at the bottom of page 80 of the transcript, so page 200 in our bundle, the question is then put, if we go to the signature page over in each document, and if we go to the signature page, at page 160 and 161, and Mr. Vik actually does make the point, but it's not picked up on by the learned judge vitally. He does make the point. I apologise, but that looks like the identical page. Mr. Lane says exactly, but the one on the left wasn't faxed to Carlisle, whereas the one on the right was. If you can go on over the page on each version one more time, we see in the version that you disclosed that there was no general partner's signature and consent. Well, there's no doubt about that. That's common ground. In that sense, it wasn't even misleading in that sense. Whereas in the execution 6 version, there is. And then the point is made that the same point arises on all of the other documents. And the question is put at line 8 of page 81 internal. Mr. Vik, having seen that, the obvious inference is the deeds you disclosed pursuant to the Part 71 order were not in fact the final versions entered into by the parties. Answer, I agree with it. It looks like this was, you know, the version 6 versus version 5, and there was an additional signature from somebody over there. Seems to be the same pages, but yes, it seems to be a different version. And it says, you knew they weren't, and you deliberately disclosed a document to support your argument that the transfers had happened in September 2008, knowing that if you disclosed those other documents, it would show that that wasn't true. That's not true. So what has happened is that it has not been pointed out, other than Mr. Vik saying, well, those pages look the same. It hasn't been pointed out that in version 26, the version at tab 25, so namely version 6, the documents at page 203 and 204, but not as it happens 205, which is the general partner signature, were in fact the same version 5.
Yeah, they were pre-signed and faxed.
So he didn't sign them twice.
No, he didn't sign them twice, but his fax signature, or rather the original signature that was on version 5 was faxed to Carlisle.
Exactly.
Yeah.
But it's
And that's
not
what
suggested
Mr. Laney put.
And it's not. But the finding of the judge was that what was so
signed it again, yeah.
essential was that he signed it twice, and she was completely unable to accept that the disclosure of version 5 can have been genuine in circumstances where she says there is this wholly unexplained fact that he had signed version 6 and therefore must have known that even if he wasn't sure of the contents of the document, he had signed version 6. But he never did sign version 6, and he clearly never did sign twice. There's no doubt about that. So what unfortunately happened was the judge wasn't shown, I make no criticism of anybody, the judge wasn't shown that these pages on the version 6, the signature pages, were actually version 5, the pages he'd already signed. And because the documents are being looked at electronically, that's not something that would have come up on the screen, because by the time you get back to the signature pages, you're not zoomed out on the bottom left-hand corner of the screen anymore. And so...
Well, you could do it. If you had them split screen and you got them side by side, it ought to be possible to see that the signatures are exactly the same.
Well, I don't criticise the judge for having failed to spot that, but what she did instead...
Well, what she failed to pick up was the point that Mr. Liney made about the fact that it was faxed.
I'll come on to that.
That's what she's failed to pick up. So she said, well, Mr. Vik signed it twice, and she's inaccurate about that because he didn't sign it twice. What actually happened was he only ever signed once, but his signature page was faxed over when it came to execute the final document, which leads to different problems for Mr. Vik from the ones that she found.
It doesn't lead to any problems with Mr. Vik because there is no evidence whatsoever that Mr. Vik had any involvement in faxing version 6. No evidence at all.
Well, it looks as if it comes from his fax, doesn't it?
Mr. Johansson works there. Mr. Vik's evidence was, I have no idea about versions 5, version 6. I sign what's put in front of you. The judge said, I don't believe you. You signed this twice. You must have realised that you signed a later version. And now you've only signed the earlier version. That is clearly not factually correct. Now, there was some contemporary evidence in relation to it shown to the court, but again, unfortunately, the way this developed in the transcript and the way it developed before the judge might again have led to some confusion. If we look back in the transcript at Bundle 1, tab 5, page 199, internal page 76 on the right-hand side, starting at line 17, the question is put, if we go to 332, we see further correspondence on 21st of October 2009 between Debevoise on behalf of Carlyle and Mr. Johansson. I'm going to come to these documents in a moment. What we see is Carlyle refusing to reuse the signature pages executed in respect of old forms and wants the signature pages to be executed at this time. That's in October 2009, correct? Let me read it. Yes. So you can see that, can't you? I'm asking you to answer the question, and the question was, they are not happy to reuse old signature pages. They are not. And so that's the way it's left. And so again, that would have fed into the judge's understanding or assumption that Mr. Vik had to sign again because Carlyle were not happy, and therefore again that there must therefore have been two versions signed, and that is why Mr Vik's evidence in relation to this is incredible, and that is why he must have deliberately put in 2015 a document which he knew was an earlier draft, because he must have signed or re-signed a later draft which he must therefore have been aware of. And all of that line of reasoning is flawed, because he never did sign and he never did have any involvement in the second version. I'll come on to show that. What appears to have happened, if we take the relevant correspondence, is in supplementary bundle 3 at tab 24. There are two exchanges here. Between Mr. Johansson and Debevoise acting for the general partner, and to neither of these chains was Mr. Vik a party. There's no evidence that he received, saw, or is in any other way involved with these emails. And the two sequences of emails, just so everyone gets the dates, as it were, is that the one starting chronologically at page 718 and then working backwards in the bundle to 716 goes from the 26th of August through to the 23rd of September. The document at page 716 being the 23rd of September. And then the document, the second of the email chains, as it were, it begins chronologically at page 720 of the bundle on the 20th of October and goes back in the bundle to 719 at 21st of October. And that is the correspondence that was being addressed in that bit of the transcript I showed you. I'm going to come back to look at it in a little more detail, what it actually says. And the position on the transcript, as you will have seen, may well have left the judge with the impression that since the general partners on the basis of this document were not happy and required a second signature, therefore a second signature had been effected. And so I've nearly finished. If I can just finish it.
Yes, I just want to make a point before we rise.
Will you carry on, and Mr. Laney can make her point when you finish this particular?
I'm very grateful. And so, obviously, there was, in fact, as we know, no second later signature page from Mr. Vik. What appears to happen from 717, item 3 on the email there, is that the signature pages to the agreements did not include the requisite witness signatures, it said. Can you please coordinate to have these pages properly executed? So we are happy to send back the original signature pages to facilitate the process. Apologies in advance. So what is happening is that Mr. Vik is not being involved again at all.
That doesn't work, because it was the witness was his wife, and her signature was on the original faxed document.
Yes, because the faxed document is September 2009 in response to this.
Mr. Matthews, what I'm pointing out is that if your thesis is correct, what is happening is that they've got something which hasn't got a witness signature on it. So it's been sent back for the witness to append a signature, which they would be doing in the absence of the person who'd signed it in the first place. And so they wouldn't really be witnessing it at all. And that would mean that there wasn't what was sent originally didn't have the witness signature on it, but what was sent originally did have the witness signature on it, and it remained on it when it was faxed over. So that doesn't add up.
It does, Melody, for two reasons. In relation to the second point, there is no doubt that the version that was faxed and that was then disclosed had the witness signature as well as Mr. Vik's signature.
Yes.
But Mr. Vik hadn't signed it again. So originally he had signed the document, version 5, but it didn't have a witness signature.
How do you know that?
Because that's what's said here, my lady, in page 717.3.
No. We've seen version 5 with a witness signature on it. And that was the one that he disclosed.
Yes,
He
because
disclosed one that had the witness signature already on it. And then then that found its way into version 6 with the witness signature on it. And then you've got something complaining about there not being a witness signature.
no, my lady, no, with respect. In August 2009, which is 717, Carlyle say, I've got this document signed by Mr. Vik. I need a witness signature on it. Mr. Johansson gets a witness signature on it. Again, doesn't involve Mr. Vik. Mr. Vik doesn't change, sign, do anything. And that version, with Mr. Vik's signature, which he always had, but now also with a witness
It
signature.
just happens to be Mr. Vik's wife.
Who is Mr. Vik's wife? But
Yeah.
So I haven't quite understood what your theory is. So what happened in your theory in September 2008? Mr. Vik signed version 5.
there's no suggestion that anything happened in
Witness.
September 2008 other than an agreement between SHI and Delagoa. In relation to the
I thought version 5 was dated September 2008. Am I wrong about
The
that?
manuscript date on it is 2008, and that's the second thing I will come on to. It was not executed in 2008, it was executed in 2009.
So why?
The only point I'm dealing with now is that the judge attached great importance to the fact that this document was signed twice by Mr. Vik, and Mr. Vik must therefore have understood or recorded or recollected that he had signed it twice, and therefore in 2015, when he provided the earlier version, he, Mr. Vik, must have known that it wasn't the executed final version. And the flaw in that is that Mr. Vik only ever signed one copy.
I'm still, I'm afraid, now very confused as to what you say actually happened. So in 2008, nothing happened.
Agreements and arrangements were entered into between SHI and Delagoa, which was Mr. Vik's father's company, for the transfer of the asset.
But nothing was signed.
Not involving the general partner. And the
No,
reason why we
I
get
think-
into all of this,
When do you say version 5 was? What we see in the bundle before us
yes,
is a signature page, which comes from version 5,
yes,
signed by Mr. Vik and witnessed by his wife.
correct. Although
When on your theory did that happen? When did Mr. Vik sign that?
the signing was before August 2009. Hence, at page 717, Debevoise say, we've got a signed document, but it's not witnessed. We need it
Why did he sign version 5 and not version 6 on that theory?
because version 5 was the one in existence at the time. Version 6, I'm going to come on to show you how version 6 came about, but version 5 is at a time when the parties were saying, we'd like an effective date of September 2008 in it, please, because that's when the deal was done between Delagoa and SHI. And the response to that in August of 2009, September of 2009, is the general partner say, well, we can't put the effective date as with the general partner of 2008 because that's too long ago. So for the agreement with, so they then produce version 6, which changes the date from 2008 to 2009, except that it records that the actual transaction between Delagoa and SHI was effective as of 2008.
But neither of the signature pages that we have, that is to say, the version 5 and version 5 faxed, corresponds to what Debevoise are describing in paragraph 3 of the email on page 717, because they say the signature pages did not include the requisite witness signature. Well, both of the ones we've got did. So they must therefore either be getting this wrong, or they've got something else altogether.
No, if one thinks back to fax machines, the document, if I send by fax a page, my version doesn't have a printout on it. It's the one that's received at the other end that has a printout on it. The reason why there's a date printed out at the other end is because that's the one that the general partners incorporated. So what you have at Mr. Vik's offices, which Mr. Johansson is dealing with, is an agreement. Mr. Vik, sign it. Mr. Vik signs it. Mr. Johansson then sends it off to the general partners. The general partners say, we're not happy with that because it's not witnessed. So what he then does is get it witnessed, Mr. Johansson, and sends it again. By this time, the document, the only one.
So there should be 2 faxes in Debevoy's file.
Well, it depends how they got the first one. That might have been sent. And the other bits of version 6 haven't got fax things on them either. It's only the 2 signature pages that have got a fax readout on it. So the first point I'm dealing with is that the judge attaches huge importance to the fact that Mr. Vik signed it. What is quite apparent, signed it twice. What is quite apparent is that he did not sign it twice. The document he signed once, Mr. Johansson got his signature on it, it stays in the office. Debevoy's come back and said, but it's not witnessed, I need a witness on it. It's then witnessed, same document, and Mr. Johansson then sends that off. So by that time, the version that Mr. Vik can produce in 2015...
Of course, because on your theory, the witness signs to say that she's seen the person signing it when she hasn't. A year later.
I have, not a year later, no, sorry. There's no suggestion that version 5 was signed in 2008. It had the date on it of 2008, that's what I'll come on to after the break.
Yeah, right.
But that had to be changed to 2009 to satisfy the general partner, because it said 2008's too long ago. The version that Mr. Vik signed, the only version that Mr. Vik signed, was signed in 2009, but with an effective date of 2008. What then happened was, and I'll come to show this afternoon, the general partner said, no, I'm not happy to have a document which says 2008 on it. I want a document that says 2009 on it. But I'll agree to mess around with one of the clauses to say, well, it's effective as between SHI and Delagoa as of 2008, but it's effective as against the general partner as of 2009. Those signature pages is the same signature page that had already been signed before. So the judge reaches her conclusion that it was signed twice, wholly wrongly. There is no justification for it. I'm not criticising in the sense that these things happen and the way they come out, but it is clearly wrong.
All right,
it is fundamental.
Oh, you want to say something, Mr. Laney?
I do. First of all, none of this is in the skeleton argument, unless Mr. Matthews wants to point us to it. So it's an entirely new point. At times, Mr. Matthews has strayed into giving evidence. It's inconsistent with other documents that were available, and I'll have to go and get those to show you exactly what Mr. Vik's case was and when he said he signed what. And none of this, of course, was put in re-examination. None of this was put in the closing submissions to the judge. So it's yet another new piece of evidence stroke case that's being advanced at the last hour. I'm happy to deal with it, but it may be helpful, if your lordship wishes to address this case, if Mr. Matthews Jr. puts it in writing by close of play today, and then we can get the documents that we know exist to show you why it's wrong.
Right, well, it's obviously a point to which Mr. Matthews attaches importance. Well,
Yes.
I think I'd worked out for myself it wasn't in the skeleton argument, but I think we do need to both understand it, and we're in the process of discussing with Mr. Matthews what exactly his case is, and your response to it. I think we may also be helped to understand whether the judge's conclusion that Mr. Vik signed it twice was a result of submissions to that effect being made to her, or whether that is, as it were, her own idea. But we're probably well past a convenient moment, but I'll say 2:05.